Florida's controversial Stand Your Ground law is at the center of a critical court hearing this morning to determine whether a trial will even take place. Retired police captain Curtis Reeves is accused of shooting and killing Chad Oulson in a movie theater back in 2014. They had an argument over texting in the movie theater. Reeves' lawyers argued yesterday that their client acted out of his own safety when Oulson verbally and physically attacked him. They used Florida's Stand Your Ground law as defense.
Mr. Reeves should be granted immunity in this case from criminal prosecution because he reasonably believed that the threat was imminent and that using deadly force was necessary.
CBS News legal analyst Rikki Klieman is here and joins us at the table. Rikki, hi.
Hi.
It's so disturbing to think that texting in the theater can lead to a loss of life. And I think many people think Stand Your Ground applies to you when you're in your home. So can you just briefly tell us what it actually means and how it applies in this case?
We always have self-defense as an affirmative defense in criminal cases. It has been recognized since time immemorial. What Stand Your Ground changed was not only in the home, that the home is your castle, or in your vehicle that you have a right to protect it, but in a public place, such as here, a theater, there is self-defense plus no duty to retreat. So in the other states that don't have Stand Your Ground, if you're in a public place to which you have a right to be there legally, you still have to retreat to the wall if you are met with force. But in Stand Your Ground, you may stand or sit, and if you feel that you are in danger of serious bodily injury or death, you may use deadly force.
And you're saying this man had nowhere to go.
Well, it doesn't matter if he had a place to go.
Yeah, you're saying he doesn't have to move here.
Exactly
you hear
correct.
The defense attorneys say that he reasonably believed the threat was imminent. How are they saying that his life was in danger?
Well, one of the things that is critical in this case is the word reasonably. He is being portrayed by the defense as a 71-year-old man at the time who was frail, who was arthritic, whose reflexive time was less, who felt vulnerable, as many 71-year-old frail people would do. And what he then did, they say, was not only subjective, that he felt vulnerable, that he was, as you can see me move, that he was being menaced, and the shot is up. It's an upward trajectory, so that he says he was sitting back and the guy was coming at him.
But
other
tell
witnesses
us what happened in the case.
Yeah, so
Rikki, tell us exactly what happened, because he's sitting in the theater. The victim is apparently texting. He goes to the management to complain, right?
Yes, he did everything right. He asked him to stop. He went to the manager to complain. He comes back in, and that's when the argument starts. It may or may not have started because he told the manager, something is thrown at the defendant.
I think a cell phone.
Probably was the cell phone. His glasses are knocked askew. He hit something in his face. The popcorn is then spilled. And according to the defense, the man was screaming, menacing at him. By the way, there are witnesses in the theater who say that the deceased's voice rose above the sound of these very, very loud previews before Lone Survivor. This is a case defendant must show by a preponderance of the evidence to the judge in a pretrial hearing that he is entitled to immunity from prosecution. No case because he, quote unquote, Anthony, reasonably believed that his life was in danger. By the way, the devil is in the details here.
Very interesting but very sad case. Thank you very much, Rikki Klieman.